Number 1. What is the role of judges in criminal cases at the trial, at sentencing?
At trial, judges act neutral referees, ensuring fair application of evidence, rules, and law. They ensure attorneys follow the rules. At sentencing, judges make critical decisions on a person's freedom or imprisonment, determining guilt or innocence and the length of any prison term.
Number 2. Define court and explain its concept in relation to the administration of criminal justice system.
A court is a judicial body that interprets and applies the law, resolves disputes, and administers justice within the criminal justice system by conducting trials, hearing cases, and issuing legal decisions.
Number 3. When does the role of judges in criminal cases begin? Discuss.
Uh, the rule of judges in criminal cases begins when charges are filed and they are oversee the legal process from arraignment to trial and sentencing, ensuring due process, fairness, and adherence to legal standard.
Number 4. Illustrate the different courts under respective jurisdiction in criminal cases.
Uh, Different courts in criminal case justice system include the trial courts, appellate courts, and Supreme Court, each with specific jurisdiction over criminal cases at various levels of the legal system.
Number 5. How, how may the court acquire jurisdiction over the case? Explain.
Uh, the court acquires jurisdiction over a case by the filing of the complaint or information, which initiates legal proceedings and by satisfying legal requirements such as subject matter jurisdiction, territorial jurisdiction, and compliance with procedural rules.
Number 6. How may jurisdiction over the person of the accused be acquired? Discuss.
Jurisdiction over the person the accused is acquired through proper service of summons or arrest, ensuring that the accused is informed of the charges against them and has the opportunity to defend themselves in court.
Number 7. What is the effect should the court not acquire jurisdiction over the case or over the person of the accused?
If the court does not acquire jurisdiction over the case or the person of the accused, legal proceedings may deemed invalid, leading to potential dismissal of the case or challenges to legality of court actions.
Number 8. Enumerate the general functions of the courts in relation to the CJS. Explain each.
Okay. The general function of courts in the criminal justice system include interpreting and applying the law, resolving legal disputes, protecting individual rights, ensuring due process and upholding the rule of law through fair and impartial legal proceedings.
Number 9. Distinguish judges from courts.
Uh, Judges are individuals who preside over court proceedings, interpret and apply the law, and make legal decisions, while courts are the institutions where legal cases are heard and resolved by judges and judicial officers.
Number 10. What are the qualifications of judges and justices?
Um, Qualifications of judges and justices ty- typically include legal education, experience in the legal profession, integrity, impartiality, and adherence to ethical standards to ensure fair and competent administration of justice.
Number 11. Do courts exercise discretion? Enumerate some examples.
Okay. Court exercise discretion in various aspects, such as bail decisions, sentencing, evidentiary rulings, case management, and interpreting legal statutes, allowing judges to make informed judgments they based on legal principles and the facts of each case.
Number 12. What is the present crisis we have in courts?
The present crisis in courts may involve issues such as case block, you know, case backlogs, delays in court proceedings, lack of resources, and efficiencies in cases management, and challenges ensuring timely access to justice for all.
Number 13. How are judges and justices of our courts selected and appointed?
Judges and justices of courts are selected and appointed through various processes, including appointment by executive branch, nomination by judicial selection commissions, and confirmation by legislative bodies to ensure judicial independence and competence.
Number 14. Define jurisdiction and venue. Distinguish jurisdiction from venue.
Uh, Jurisdiction refers to the legal authority of a court to hear and decide a case, while venue determines the proper geographical location where a case should be heard. The jurisdiction focusing legal authorities and venue on the physical location of the court.
Number 15. What is meant by continuous trial?
Continuous trial refers to the no uninterrupted, expeditious conduct of court proceedings, ensuring timely resolution of cases, efficient use for court resources, and respect for the right parties involved in legal proceedings.
Number 16. Is there an existing provision of law governing suspension of sentence for youthful offenders?
Yes, there is an existing provision of law governing suspension of sentence for youthful offenders, allowing for the rehabilitation and formation of young offenders through alternative sentencing and support programs.
17. How are judges controlled in their activity that might affect the image of the justice system?
Judges are controlled in their activities that might affect the image of the justice system through judicial ethics, code of conducts, oversight by judicial review bodies, public scrutiny, and the controllability of mechanisms to uphold judicial integrity and independence.
Number 18. What is motion to quash? What are its grounds?
A motion to quash is a legal request to avoid or dismiss a case of a specific legal action with grounds including lack of jurisdiction, defects in the charging documents, violation of constitutional rights, or procedural errors that warrant dismissal of the case.
Number 19. What is arraignment?
Uh, Arraignment is the court proceeding or the accused is formally informed of the charges against them as to to respond to allegations in criminal case.
Number 20. Is the presence of the accused necessary in arraignment?
The presence of the accused is necessary in arraignment to ensure that they are properly informed of the charges, understand their rights, and have the opportunity to enter a plea in court.
Number 21. May an accused validly plead to a lesser offense without the consent of the offended party?
Uh, okay. An accused may plead to a lesser offense without the consent of the offended party if the prosecution agrees to plea to the plea. Ay, ulitin na lang ako sunod. Igual,
Number 20.
dire,
Ay, balik ko ibak.
i-delete ito.
Imbak ko na lang muna. Number 21. May an accused validly plead to a lesser offense without the consent of the offended party?
Uh, An accused may plead to a lesser offense without the consent of the offended party if the prosecution agrees to plea to the plea deal. The court accepts the plea and the accused guilt to the lesser charge as part of the negotiated resolution.
Number 22. When can there be a pre-trial?
Ah, a plea trial can occur after arraignment and for the trial, where the prosecution and defense may engage in discussions, present the legal arguments, negotiate plea deals, address evidential issues, and prepare for trial proceedings in the criminal case.
Number 23. What are the purposes of pre-trial?
Okay. The purposes of pre-trial include discussing legal issues, exchanging evidence, exploring plea agreements, and preparing for trial in a structured manner.
Number 24. What is the order of trial?
Okay, the order of trial specifically involves jury selection, opening statements, presentation of evidence, witness examination, closing arguments, and jury strategies before deliberation and verdict.
Number 25. What is the concept of appeal?
Okay. Appeal is the legal process where a higher court reveals the decision of a lower court to determine if errors were made in the application of law or legal procedures.
Number 26. What is the importance of adhering to the order of trial?
Okay, adhering to the order of trial is important to ensure fair and orderly proceedings, protect the rights of all parties, maintain legal standards, and uphold the integrity of the judicial process.
Number 27. When may trial courts modify the order of trial?
Okay. Trial courts may modify to order a trial based on legal requirements, case-specific circumstances, um, judicial discretion, and the need to ensure efficient and effective resolution of pillars disputes.
Number 28. What is the importance of the courts in the administration of CJS?
The courts play a vital role in the administration of the criminal justice system by interpreting and applying the law, resolving legal disputes, protecting individual rights, and ensuring fair and impartial legal proceedings.
Number 29. Who has the control in presenting the states of evidence?
Uh, the control in presenting the state's evidence lies with the prosecution, who is responsible for presenting evidence, calling witnesses, and proving the case against the accused.
Number 30. May an accused be discharged as a state witness?
An accused may be discharged and as a state witness if in certain conditions are met, such as providing vital information, cooperating authorities, and being deemed necessary for the prosecution of other individuals involved in the crime.
Number 31. What is the effect of the discharge of accused?
Um, the discharge of an accused as a state witness may lead to immunity from prosecution, leniency at sentencing, or other benefits in charge for cooperation with the prosecution against against the accused to co-accused individuals.
Number 32. Define judgment.
Uh, Judgment is the final decision or ruling of the court in any legal case, determining the rights, responsibilities, and legal consequences for parties involved based on the law evidence presented.
Number 33. What is the nature of a guilty plea?
A guilty plea is an admission of guilt by the accused, waiving the right to trial, accepting responsibility for the offense charged, leading to potential sentencing or plea agreement negotiations.
Number 34. What is the fourfold duty of the court in the arraignment?
Um, the fourfold, fourfold duty of the court in arraignment includes performing the accused charges, ensuring understanding of rights, entering plea to place setting to the court for the trial proceedings in a criminal case.
Number 35. What is the weight of evidence required in order to convict the accused?
Uh, okay. The weight of evidence required to convict the accused is proof beyond reasonable doubt, the highest standard of proof in criminal cases, where the evidence must be convincing and to lead no reasonable doubt of guilt.
Number 36. Is appeal a constitutional right?
Um, Appeal is a legal right granted based on the statutes in court rules allowing parties to challenge the lower court's decisions for a higher court based on errors and facts, and law facts and legal procedures.
Number 37. What is meant by acquittal and its effect?
Acquittal is the legal verdict of not guilty in a criminal case, resulting in the accused being cleared of charges, released from custody, and protected from further prosecution for the same offense.
Number 38. Is there an existing provision of law governing suspension of sentence for adult offenders?
Yes, there is an existing provision of law governing the suspension of sentence for adult offenders, allowing for the suspension of the execution of a sentence under certain conditions.
Number 39. Distinguish suspension of sentence from suspension of promulgation and its effects.
Um, Suspension of sentence involves delaying the enforcement of a sentence, while suspension or promulgation delays informal announcement to court decisions and effects on the execution and finally um, of the sentence legal proceedings.
Number 40. Who has the right to appeal?
Okay. The right to appeal is generally held by parties, agreed by court decisions, allowing them to challenge legal errors, s- to seek review of judgments, and ensure the fair application of law to legal proceedings.
Number 1. Differentiate the schools of thought in explaining criminal justice system.
Uh, for positive law theory, it emphasizes a strict adherence to existing laws and legal procedures in determining justice within the system. And for social good theory, it considers justice in terms of its impact on society, aiming to maintain social order and progress through fair treatment and outcomes. And lastly, for natural right theory, it advocates for justice rooted in universal principles beyond human creation, possibly including divine or natural laws, guiding the system towards fairness and righteousness.
Number 2. When can we say that there is justice?
We can say that there is justice when justice is achieved, when fairness, equality, and adherence to legal principles are upheld in legal proceedings, ensuring that the rights of individuals are protected and legal outcomes are based on due process and the rule of law.
Number 3. Explain the following maxims. What is nullum crimen, nullum pena, sine lege?
Okay. For long krimen, nalong pena, sinelehe, it means there is no crime when there is no law punishing it. It states that an act cannot be considered a crime and punished unless it is expressly prohibited by law beforehand.
What is actus non passet reum nisi means set rea?
For actus non facit reum nece cetria, a crime is not committed if the mind of the person performing the act complained be innocent. Okay. That maxim emphasizes that criminal liability requires both a wrongful act and a guilty mind. In other words, a person cannot be held criminally responsible for an act if they did not have the intent to commit the act.
What is actus me inveti factus non est meus actus?
For actus me inveti factus non est meus actus, it means an act done by me against my will is not my act. It suggests that if someone is compelled or coerced into committing an act, they cannot be held responsible for it because it was not done by willingly.
What is ignorantia lihis niminem excusat?
Okay. For ignorancia lehis neminem excusat, it means that ignorance of the law excuses no one. Okay. That maxims holds that individuals cannot avoid legal consequences by claiming ignorance of the law. In other words, not knowing that an action is illegal is not exempt a person from liability if they commit the prohibited act.
Number 4. When can there be crime? Explain.
Crime,
Number 4. When can be there be crime? Explain.
a crime, of course, when an individual commits an act prohibited by law with a guilt of mind, resulting in harm to society or individuals, violating legal norms, and warranting punishment under the criminal justice system.
Number 5. Explain the different stages of the criminal justice process.
The different stages of criminal justice process include investigation, arrest, booking, initial appearance, preliminary hearing, indictment or information, arraignment, trial, and sentencing and appeals, each serving a specific purpose in the legal process from investigation to resolution of a criminal case.
What are the 7 penal institutions?
The first one is the new Bilibid prison in Muntinlupa City. It is the main prison in the Philippines, managed by the Bureau of Correction under the Department of Justice. As of October 2004, it has an inmate of population of 16,747 and had an initial area of 551 hectares. Second is the Correctional Institution for Women in Mandaluyong City and the Correctional Institution for Women in Mindanao, Panabo, Davao City. Okay. The Correctional Institution for Women in Mandaluyong City and Mindanao are women's prison operated by the Bureau of Corrections. The Correctional Institution for Women in Mandaluyong was inaugurated of, on September 18, 2007 as the second facility dedicated to rehabilitating female offenders. The third is Ihawig Prison Ihawig Prison Penal Farm. The Ihawig Prison and Penal Farm in Puerto Princesa City, Palawan, is one of the 7 units operated by the Bureau of Corrections under the Department of Justice, initially designated for exile offenders during the Spanish regime. It was formally established during the American occupation. Fourth one is Sablayan Prison in Penal Farm in Occidental Mindoro. Right. It was established on September 26, 1954 by the Presidential Proclamation number 72. It covers approximately 16,190 hectares. The fifth one is San Ramon Prison and Penal Farm in Zamboanga City. It was initially established to house Muslim rebels and opponent Spanish rule, located on the 1,400 hectare property by the Hulu Sea. It was destroyed during the Spanish-American War, but it reestablished in 1907 to house the prisoners from Mindanao. In 1950, it came under the Bureau of Prisons Management. The sixth one is Leyte Regional Imprisonment, Tinabuyog, Leyte. Okay. It was established in 1973 by a presidential decrees number 28 with a capacity of 500 inmates. It follows an agricultural format and offers rehabilitation activities, and it admits convicted offenders from Region 6 and the National Penitentiary in Muntinlupa. And last one is Davao Imprisonment and Penal Farm, Davao. Okay. It was established on January 21, 1932, covering 30,000 hectares with 8,000 hectares reserved for the prison. It was the largest prison in the country during World War II and was used by the Japanese Army as a garrison.